Hello, ladies and gentlemen. How are we today? Are we still full powered and energized, although it's the last session of the day? Yes. Okay. So our topic of the discussion is it's about the multilateral environmental agreements. MEAs, known as the Rio Conventions, are configured to share goals in sustainable development and environmental governance. However, the implementation of these conventions has often occurred in silos, leading to challenges in coordination and maximizing the co-benefits. To frame the context for the discussion, allow me to welcome our keynote speaker. She is the Principal Secretary from the Ministry of Environment, Republic of Indonesia. Please join me in welcoming Ibu Rosa Vivien Ratnawati.
Distinguished guests, colleagues, and friends, good afternoon, selamat sore. It is a privilege to be here with you at COP30 at a moment when the world eyes are once again on our collective ability to confront climate change with urgency and unity. For Indonesia and for all nations represented here, climate change is no longer a distant threat. It is the defining challenge of our era. Thank you for gathering here today. It is an honor to discuss how Indonesia can strengthen its climate policy through the integration of multilateral environment agreements, we call it MEA, tools that are more essential than ever as the world confronts the triple planetary crisis of climate change, biodiversity loss, and pollution. Ladies and gentlemen, here at COP30, it is clear that climate change is the accelerant that intensifies the other two crises. Climate change accelerates ecosystem decline, biodiversity loss, weakens natural resilience, and pollution compounds environmental and health vulnerabilities. For Indonesia, a nation with extraordinary biodiversity, vast coastlines, and millions of people dependent on natural resources. This crisis touches every layer of society. These three crises do not unfold in isolation. They are deeply connected, creating feedback loops that intensify risk to our ecosystem, our health, and our economy. And for a nation as vast and biodiverse as Indonesia, the stakes could not be higher. This is where the global environmental governance system and multilateral environmental agreement in particular play a crucial role. Agreements like the Paris Agreement, the Convention of Biological Diversity, CBD, the Montreal Protocol, and the Basel, Rotterdam, and Stockholm Convention help countries align action, share responsibilities, and build collective momentum toward environmental resilience. Ladies and gentlemen, my friend, but to truly understand the strength of MEAs, we must acknowledge the foundation they stand on. The long evolution of international environmental law built not only on treaties, but also on soft law instruments that shape the principle guiding global cooperation today. When states face barrier in reaching binding agreement, they often turn to non-binding declaration to articulate shared values. The 1972 Stockholm Declaration and the 1992 Rio Declaration are prime examples. Both articulated the non-harm rule, which has since become a touchstone for most environmental agreements. The Rio Declaration in particular became a principal reference for numerous MEAs. It laid out foundational environmental law principles, including precautionary principles, sustainable development, and common but differentiated responsibilities, principles that continue to guide both negotiations and implementation. Even though many MEAs incorporate soft law concept, these principles have nonetheless become a legal and normative basis for addressing environmental challenges worldwide. Ladies and gentlemen, we know common but differentiated responsibilities, or CBDR, initially expressed in the Rio Declaration, appears explicitly in the UN Framework Convention on Climate Change, in both its preamble and operative provision. Despite being non-binding at first, the principle shaped decades of climate negotiations and ultimately influenced the architecture of the Paris Agreement. Soft law has also played a regulatory and preparatory role. The 1987 London Guidelines helped shape the prior informed consent mechanism that later became binding under the Rotterdam Convention. The FAO, International Code of Conduct on Pesticide Management, and subsequent guidelines further filled regulatory gaps left by binding agreements such as the Basel Convention, Stockholm Convention, strengthening global norms for chemical safety and hazardous waste management. Ladies and gentlemen, this evolution from soft law norms to binding commitments demonstrate that MEAs do not emerge in isolation. They are part of a larger continuum of international cooperation built on shared principles that countries have endorsed repeatedly, even when not legally obligated. For Indonesia, integrating these MEAs means recognize this linkage and using them to reinforce national policy. It means designing climate strategies that also support biodiversity conservation and pollution reduction. It means coordinated action across ministries, stronger monitoring system, and deeper engagement with communities, because environmental protection is most effective when it is holistic and inclusive. So, distinguished colleagues, Climate change is reshaping our world faster than our institution can respond. But the international environmental regime rooted in Stockholm, shaped in Rio, and strengthened by MEAS, give us the tools to build a resilient future. Indonesia is committed to doing its part by integrating MEAS into our climate strategies. We are crafting policies that are robust, coherent, and grounded in decades of global cooperation. At COP30 today, let us renew our commitment to climate leadership built on the principles, agreements, and shared responsibilities that brought us here today. Thank you very much.
Thank you, Ibu Fifin, for the keynote, and thank you for pointed out that at present the international law requires integration on environment binding agreements. So I guess we have no choice, but we have to just work work on incorporating MEAS into our respective climate strategy. Thank you for that, Ibu Fifin. Okay, for the upcoming discussion, we will touch on how Indonesia effectively harmonize the commitments under MEAS and align it with the national framework. What approach can be adopted to advance synergy across MEAS in order to achieve both national and global climate targets? How can countries leverage their shared objectives to promote coordinated action and resource optimization? So I would like to call upon all the speakers to stage. Professor, University de Chile and Executive Director of NGO FIMA Chile, Dr. Ezio Costa Cordela. Deputy Director of Indonesia Center for Environmental Law, Lasma Natalia. World Youth for Climate Justice, Nicole Ann Ponce. To lead the session, please welcome Indonesia Ocean Justice Initiative Representative Steffi Juwana.
Hello, everyone. It's so good to see a full house today, the last session of the day, but I think everyone is still in a very good spirit. So I guess from our keynote speaker, we've already heard about briefly what we're going to be talking about. So basically here at COP, we already know the condition that we are in right now. We already know the science. We already know what we have to do. But now the big question is, so how can we get everyone to actually do it? And the answer is, we need the law. And basically, that is something that we're going to be talking about in the next an hour or so. We're going to be talking about the role of law, the role of international treaties, also adjudication as well, and also how we can integrate those frameworks into more concrete actions. And we have a lineup of speakers here. And the Master of Ceremony has already introduced all the speakers, so let's just get to the discussion. So first, I'd like to welcome Professor Ezio Costa Cordela, the Executive Director of FIMA. And I think from you, we'd like to hear about, so Bu Fifin has, she successfully described how these treaties are they are across of several topics. So how can we make this as an integrated approach? How can we make this as a very concrete action to something that is very coordinated so we can optimize all the resources that we have to get to those goals? You have 15 minutes to answer the question. Thank you.
Okay. Hello. Thank you for the invitation to the Center of the Indonesian Center of Environmental Law, and thank you to the Ministry also for her words. I think that it's a very good description and an opening for what I'm going to talk about as well. So my idea now is to show, how do I change the slides? they will change. My objectives now is to show, to understand precisely these interlinkages and synergies between these three Rio Conventions, but also with other MEAs, and that's the important part of it, to understand how different international environmental law agreements can work together, and to explore how countries can leverage, can share objectives such as nature-based solution, ecosystem restoration, and so on and so forth. These concrete measures that we have to take. In order to understand how these measures can be taken, I think that the most important thing is to actually understand where are the connections between the different treaties and the different conventions. And as the next slide shows, thank you, to understand this, we have to start from a point of common ground, common understanding about environmental law and which kind of relations are being regulated by environmental law. And environmental law uses as mechanism international treaties, use constitution, use laws and regulations, but the basic idea is to regulate the way that we relate with nature and among us using nature as a proxy, no? So when we look at environmental law, we will see some regulations that are created to guide the way that we use natural resources, the way that we use nature, but also some other regulations that are created to enhance our lives, I mean to put a better well-being in our lives, to protect nature as a value on itself, and to protect future generations. Because what we are doing is to use nature in a way that can affect others. And this is why the principle of non-harm, for instance, is that important in environmental law. This relation that we have with nature, we have it at least from three different perspectives, scenarios, spaces. We have a relation with nature as persons, as people, but we also have a relation with nature as a state, which is different than the one that we have as person or as communities. And we have a relation with nature as a society, which involves not only our laws and regulations, but also our culture and the way that we do things in each day. So having this in mind, the next slide will show, and this is a little bit more complicated, but as you can see here, we have been creating, as a global society, we have been creating a way to understand these relations through one very important mechanism, which is the right to a healthy environment. And the right to a healthy environment is included in most of the constitutions in the world, including the Indonesian constitution, and it has been recognized by most of international courts and tribunals, and it has been included in a number of international treaties throughout the years. But it's not recognized as a common entity. Not every part of the world thinks the same when thinking about the right to a healthy environment. Not every court or international tribunal thinks the same when discussing about the right to a healthy environment. And this is something that we are going through, I will say, no? Because what you can see in this map, it's the different kind of connections that other rights have with the right to a healthy environment. This is the right part of the left part of the chart. You can see different rights that has been connected with the right to a healthy environment in different jurisdictions. So, the first one up there is the right to privacy and freedom from humiliation. This is the right to develop the family as well, which is the right that that the European Human Rights Conventions in the Article 6 states as one of the human rights, and is the one that the European Tribunal of Human Rights has taken as the basis to create or to recognize the right to a healthy environment. So, for the European way of thinking about the right of the healthy environment, what is important is that each person and each family can have a privacy and can have a development of their life that is connected with their own views and it's not interfered by things as pollution. No, if we look at the first decision on this matter in Europe, it was about noise in a house. No, so and the court said, well, if the place is too noisy, then we cannot have privacy. Therefore, there is a right to a healthy environment. But it's not the same in Latin America. It's not the same in Africa. The connections are different. So, for instance, now I see that the translation is not very good, but anyway, for instance, in the Latin American context and in the African context, we have been recognizing some connections between the rights of indigenous people with the right to a healthy environment. And we say, the Inter-American Court of Human Rights says this, there is a right to development that is especially applicable to indigenous people, and that right to development is the one that leads us to recognize the right to a healthy environment. The same thing is said by the African Commission on Human Rights. And also, we connect in Latin America the right to life with the right to a healthy environment, which for me is very basic. I mean, we need a healthy environment to live, but it's not the same in each part of the world. And within this right to life, we have the right to water, the right to food, and the right to health. And these are the important things for the right to a healthy environment. In the African way to see the right to a healthy environment, we have a different thing, which is the right to development and the right to the people to take things from the earth and use them to develop. And in the Arab world, we have a right to a healthy environment, which is also connected with the right to house, the right to food, the right to water, and so it has been thought from this idea of developing a way of life. No? So these are different ways to see the right to a healthy environment that now, from 2023 on, should be included in the international recognition that the UN did about the right to a clean, healthy, and sustainable environment. These three words, clean, healthy, and sustainable, have to be filled. They haven't been filled yet. I mean, there is no that much work yet into understand which is the way that we are now as a planet recognizing the right to a healthy environment. But what we do know is that this right puts some obligations on the states, and puts some obligations on the people, and puts some obligations on companies. And this is the thing that has been developed by especially the advisory opinions of the International Court of Justice, the Inter-American Court on Human Rights, and the Tribunal of the Law of the Sea in the last 2 years. So now we are building some connections to understand the deepness of the interlinkage between these different treaties and between these different rights. And as we can see in the next slide, this means to overcome the separation between regimes. We are now here in one of the regimes. No, this is the climate regime. This is led by the UNFCCC. This started with the convention in 1992. We are working around the Paris Agreement of 2015. And there are countries that actually say that is this regime only, this is the only regime that can talk about climate solutions, for instance. No? During the hearings in the International Court of Justice, many countries said that. We are not going to comply with general international law because in what regards mitigation of climate change, what we have to comply with is the Paris Agreement. And this is part of this idea of regimes that are not connected between them. No? And so we have the climate, we have biodiversity, we have water, we have oceans, access rights, and so on and so forth. There is a number of different regimes that are, from a bureaucratic point of view, they're actually being worked as silos. So we have different meetings, we have different treaties, we have different access points, and so on. But these different silos are connected. And this is what we can see in the next slide, which is basically the same. But what we can see here is that all these silos are not silos, no? Are part of a system. And this system is the system of international environmental law. And this is probably one of the most important things that the advisory opinion of the ICJ last year stated, no? These are all part of the same, and this means that, for instance, the principles that are stated in the Rio Declaration have to be applied in every regime. And that means that here, in this regime, climate change, we have to apply prevention, precaution, participation, polluters pay, and so on. For me, it's not something new. No? For me, this is a very basic idea. But for the system, it's a new idea because it was not stated in a court decision before. So now we have this tool to push for the creation of connection between the regimes, of a more integrated idea. And this integration, as we can see in the next slide, this integration is not only, I lost my, the next slide, thank you. As we can see, these connections are not only within international environmental law, but within international law. And this is what the ministry was explaining very well, which is that there are some basic principles of international law that we have to comply with. Non-harm, cooperation, which is that those are the most basic ones, and due diligence in the way that we, as the states and these regimes, deal with the impacts of, for instance, climate change in people. No? This is basic, but has been forgotten. The idea of non-harm, it's a basic rule of law since 2,000 or 3,000 years ago. But in this regime, was not here, no? And now it's here again. We bring it back. And this bringing back the idea of non-harm should curve the way that countries are doing things. And we know that not all the countries are nowadays willing to participate or to collaborate with each other. But we also know that the only way to solve planetary crises such as the climate crisis is to cooperate. And this cooperation has to be in good faith, and this cooperation has to be thinking about non-harming others. Which others? Other people that live in the world, but also the people that will live after our time of life. And hopefully also not to harm the nature and the other lives that goes with us in this planet. But this is the basic idea, very basic, but that has been brought back by the advisory opinions in the last 2 years. So with this in mind, next slides, with this in mind, I can conclude that the international conventions, all of the international conventions that we saw before, share basis and share logic. And the logics are, on one side, the logics that we can see from the right to a healthy environment, which is this idea of development and the idea of the right to life and privacy. And on the other side, the basic ideas of international law, such as no harm and cooperation. And international environmental law cannot be understood without looking it as a part of international law, and it cannot be understood as a continuum between the most basic international agreements and the national regulations. when we see at the regimes, we can also connect the regimes with national laws. We will have a climate law, we will have an environmental law that states evaluation of projects. For instance, we will have a waste management law, and all these laws are important, but not as units, but as a system. And that system is based on this basic idea that I was showing you before. Next slide, which is the ending of this. Thank you very much.
Thank you very much, Professor Cordello. You've shown us a very interesting point of view. I guess what I'm getting from you is that, in other words, you're saying that if we want to be successful in one regime, there is also a spillover that we can expect in other regimes. Or in other words, if you are failing in one regime, you cannot expect a success in other regime as well. And you've also mentioned that this connection has already been highlighted in several tribunals as well as several advisory opinion. And one of them is the ICJ advisory opinion. And with that, I'd like to shift to Nicole to talk more about the ICJ advisory opinion about the concerning climate change and how it guides the NDCs of the countries to achieve our common goals. So I guess what we want to hear from you is that, so how do you think that advisory opinion can contribute to a stronger national climate plan and actions? And how do you see it mandating like the alignment of these various environmental agreements that we have?
Thank you. Hello? Hello. Okay, this one works. Thank you so much, Steffi. And just to give a bit of a backgrounder, we're actually the youth global movement that started the ICJ Advisory Opinion campaign since 2019. Well, it started in the Pacific with our friends, 27 law friends, and amplified by the world's youth. So from getting the state of Vanuatu to sponsor the resolution all the way to the United Nations General Assembly, which was adopted by consensus, did not even have to pass through a vote because 132 countries co-sponsored the resolution, which I think is really important to highlight because we did not even allow these major polluters to say no to the resolution, which I think is really a significant testament also to multilateralism. And all the way to the oral hearings of the ICJ advisory opinion, it is the most participatory. It's the first in history, this much country participating before the proceedings, before the International Court of Justice, which before was really this closed door wall. Like many, in fact, international lawyers and even countries had no idea how to be involved in these processes. There was huge barriers to participation. But because of the ICJAO alliance and this global movement that we were able to do and to support, I mean, I've not just in these spaces, but in the streets, in the halls, in negotiation rooms, we were able to reach this point. So, needless to say, this is really a historic moment because this is also the first COP since the ICJ advisory opinion ruling came out. So the court gave us a lot of things to work with and very strong language and obligations of states. And as well as Ezio mentioned earlier, that really that nexus of climate change and human rights, which before was not quite clear, and in engaging in speaking with states, this was also a point of contention. Is there really a nexus between climate change and human rights? But thankfully, the court has reaffirmed that and in fact emphasized that the right to a healthy environment is a precondition to the full enjoyment of human rights. So, and the also equally important, I would say, is that they emphasize the legal consequences of breaching these obligations. Because in drafting the legal question that was supposed to be submitted, passed before the United Nations General Assembly, even drafting the legal question was tricky because we know that when states hear of obligations and even more legal consequences, they're often on the fence. So the fact that we were able to make sure that the language of obligations and duties and the legal consequences was included in the legal question and the one submitted before the ICJ, that is also extremely powerful, I would say. So after the decision in July in 23, we call it now the International Climate Justice Day. We have been quite relentless in developing strategies for implementation because it's important to note that this is quite unprecedented and there's a lot of things to unpack and to analyze, but we've already started identifying implementation pathways, especially on building capacity, as you guys have mentioned already, and I think in previous panels as well. So the AO is already the advisory opinion is already being referenced in domestic courts, in advocacies and in policies. And I think that, you know, global climate governance can feel sometimes out of touch, and unsurprisingly so. So that's why it's really important the building blocks is in national action plans. That's what we're trying to discuss here. And the ICJ's language on that was very strong on nationally determined contributions. The ICJ clarified that states have limited discretion over NDC content, and each NDCs must reflect its highest possible ambition, make an adequate contribution to the collective 1.5 goal, which is the legal red line and the temperature goal all states must abide. And also, it must become more demanding every 5 years and be informed by the global stock dates. So the ICJ clarified that countries' NDCs, not just NDCs, but adaptation, mitigation efforts, and even finance have to be aligned with a 1.5 degrees temperature goal. So that's the legal red line. So in engaging with governments and states, advocacy surrounding NDC is even more crucial. And we like to call this the ICJ test. Our states and governments informing and confirming to the language of the ICJ when it reaffirmed what should be the content of the NDCs. And I encourage everyone to go back to their countries and when engaging with your states, with your state officials, to look at and to hold them accountable and look into the NDCs and whether or not it's compliant to the law. So as an example, the ICJ AO also have significant implications for the law in the Philippines. I say that because I'm from the Philippines, potentially leading to an even stronger environmental protections, enhanced human rights safeguards, and more effective climate change mitigation and adaptation strategies. In one of the recent Senate hearings in the Philippines, this landmark opinion was already referenced and said to strengthen Philippines' legal and moral standing to demand scaled-up climate finance, technology access, and loss and damage support from high-emission countries and fossil fuel corporations. So these implications are significant also because there's actually currently a lawsuit filed called the Odette case. It is a legal action against Shell by multiple claimants across the Philippines. These are survivors of the tropical cyclone that left a trail of devastation in 2021. So it's extraordinary because ordinary people in the Philippines are now doing an extraordinary thing, suing these huge corporations, suing Shell. And the legal team has already made reference to the ICJ AO in the lawsuit. So again, when speaking about strengthening national climate plans and action, the ICJ opinion can further highlight the connection between climate change and human rights, particularly the right to a healthy environment. Before this, we had a panel before the WHO pavilion and emphasized the right to a healthy environment. And when we speak about that, we speak about access to clean water, clean air. So we address also these pollution because it's an affront to people's dignity and right to life. Also, as another example that maybe we could draw inspiration from is that the ICJ advisory opinion is an authoritative reference to reinforce existing binding obligation. For example, there's a pending bill in the Philippines called Klima Bill. It means Climate Accountability Bill, which will introduce robust provisions for corporate accountability, including due diligence standard and novel approach to address those suffering loss and damage. In the lead up to COP, we didn't have much time to prepare, but we actually developed what we call our pocket guide for negotiators and allies, where we extracted, I'm happy to share this to everyone, and we have a QR code, you can access this one, where we extracted provisions of the ICJ advisory opinion into different negotiation tracks. So whatever track's agenda you're following, to be sure you can use the AO as an authoritative reference, and I'm happy to share this later on. So finally, to answer Steffi's question earlier on how does the advisory opinion mandate or reinforce alignment between multilateral environmental agreements, actually in paragraph 187 to 195 of the advisory opinion, the court said that the UNFCCC, the Kyoto Protocol, and the Paris Agreement complement each other. The Framework Convention establishes the ultimate objective as well as the basic principles and general obligations of states in respect of climate change, which means that the advisory opinion does not supplant or replace the Paris Agreement or UNFCCC, but is complementary to it. This can be used, and especially in this framework, this can be used to counter arguments that the UNFCCC is no longer relevant or that what matters is solely what is contained in the Paris Agreement, because the court was clear these are complementary to each other. And this provides a crucial red line, as it means that in adopting decisions, parties should be considering whether those decisions are capable of preventing climate harms and in line with international law. So just to wrap up, as Secretary Ratnawala said, international law needs integration. And international law, I would like to emphasize that international law applies in negotiation rooms in these spaces. It doesn't stop. And even more relevant at COP is that we should highlight that the courts have spoken. We're not creating new obligations here. The court has only clarified already existing binding obligations. The law is clear. The science is clear. Now we need our states to act, and politics has to catch up. So I'll end with that. Thank you.
Thank you very much, Nicole. And I guess it's very exciting to see that the ICJ advisory opinion is actually creating a very big influence in national policies as well. You've mentioned about the EU, you mentioned about in the Philippines. I guess because we are in the Indonesian pavilion right now, it's also great to hear about Indonesia. Not only how the advisory opinion also influenced Indonesia, but I guess also how the outcomes of these negotiations during COP that has been happening for days. How do you see that also strengthen Indonesia's commitments around climate issues? And I guess in terms of its commitment in the national level, do you see any key factors that have to be increased? For example, like participation or mobilization of resources or other things that might be contributing to the success of Indonesia achieving the targets. So next is Ibu Lasma.
Okay, thank you. Good afternoon, everyone. So I will share 4 key areas in this present. Next, please. Next. Next. Okay, 4 points that I want to share. The first one is the growing synergies across the Rio Convention and SDGs. And then we will look how these synergies translate into Paris Agreement implementation. And then we see the synergy between COP30 agenda with negotiation stream. And the last one, updates from the first week of negotiation and what outcomes we need to look forward. Next. In the synergy within the Rio Convention, we see one of the central messages put forward by the COP30 president is the need to address climate change, biodiversity loss, and land degradation in an integrated manner. These are not separate challenges, they are interconnected, and their solution must also be connected. From that, we see that within the Rio Convention, this means ensuring the UNFCCC, CBD, and UNCCD work in mutually reinforcing way. A more coordinated approach can help avoid duplication, close existing gaps, and accelerate progress toward global goals. So one important initiative driving this shift is the Circle of Presidencies, which brings together the leaders of climate, biodiversity, and desertification COPs. It's proposed to be better align their agenda so the process in one COP can support progress in other. The next one. We also see the emphasis of integration reflected to the first global stocktake. Many parties underscore the importance of linking climate action with biodiversity conservation, sustainable land management, and overall sustainable development. So if we see the COP30 action agenda designed on that perspective, with purpose, the map and it connect existing initiative from previous COP and also identify opportunity for synergy and scale up what is already working. This approach helps ensure that efforts are streamlined and strategic. And if we see next, if we see the COP30 action agenda is designed to create strong and synergy. Because it's have guided by the outcome of first GST and includes 30 key objectives. And if we see all the objectives across 6 major thematic area, including energy, forest, and governance. So the intention is to create coherent framework that support parties in implementing GST recommendation. Okay, next. So the next we see how the progress in the first week negotiation. I want to highlight important points that in the discussion of energy transition and forest thematic, several parties including New Zealand and members of the IAG Environmental Integrity Group emphasize the importance to ensuring that biodiversity, deforestation, and the energy transition are clearly reflected in the scope option under negotiation. So I want to highlight that under there is two progress we observe. First is under GST outcome implementation, scope option 2 includes energy transition, forest, ecosystem, nature-based solution, and biodiversity. The other one, the SBSTA chair has sent a draft decision of synergy between the Rio Convention. It includes proposal from different groups, so party will need more time to review and discuss it. A few points from this one is the link between just transition pathway, ecosystem integrity, and biodiversity protection, including through ecosystem-based adaptation approaches. From what I say from Rio, the climate action, the implementation of SDGs, and also the climate, the action agenda. Next, please. ISO perspective, there are several outcomes that we consider particularly important to safeguard moving forward. First, effective integration of CBD and UNCCD agenda, especially regarding halting deforestation and protecting biodiversity across various items such as the Just Transition Work Program, GGA, and also GST implementation. The second one, ensuring that GST outcomes remain aligned with one-point pathways, including commitment relating to ending deforestation and supporting a just transition. So the link is just transition and also protecting the biodiversity and forests. The third one, strengthening the alignment between national biodiversity planning, Indonesian biodiversity planning, and climate policy, including NDCs, so that biodiversity is systematically integrating into planning and implementation. This is the important point because before we don't, before we talk about the climate policy, but now the biodiversity and also the what I want to say, how to protect the forest and biodiversity is coming now. So we have to look that it's not only just transition, but when we doing just transition, we will also align with the forest protection and biodiversity. And the last one, the Just Transition Work Program should explicitly refer the global commitment to phase out fossil fuels as part of the broader energy transition narrative. This is important because it is still like negotiate about the issue. This inclusion provides a strong signal toward accelerating the transition away from fossil fuels. So that's 4 points that maybe Indonesia we have to look forward, and we hope the integrating approach will contribute to faster and more effectively global action. Thank you very much.
Thank you very much, Mbak Lasma. A lot of optimism, a tone of optimism there, and also a lot of hopes and criticism as well. So I guess we still have a lot of time, so means that more time for question and answer. So if the audience have any questions, we can, okay, one from the back. Okay, we can do one question first.
Hi, good afternoon. My question is, how can we get to an agreement with international law and also be considerate of each environment's specificities without being too broad, and also considering each climate so we can actually get to like strengthen the environmental law in the world?
I guess that question can be addressed to Professor Cordero.
Thank you. I understand it is a challenge, of course. It is a challenge because law has been built from how do you say it? In a way that divides things. It's a mechanic way to see the world, no? And for me, I would say that integrate a systemic way to see the world and the law will be the path to overcome this difficulty. And the systemic way of understanding law is not that hard. I mean, it's possible. What is hard is to overcome the difficulties to integrate the connection between material things into the law, because those connections have not been in the law arrangements that we have nowadays. So to be more concrete, when we look at property rights, for instance, we usually think about the owner of something as a person that can do whatever with that thing. But we are not taking into account that that thing, maybe a tree, is not only a tree, but it's also part of an ecosystem. And it's also a way to clean the air, and it's also the habitat for a species. So all these different characteristics of these things that have been put into property, I believe that we have to integrate them into the way that we think law. Also because these things that I mentioned before are usually known now as ecosystem services, no? And when we look at ecosystem services, when we think about those issues as ecosystem services, we are repeating the same mistake, and we are dividing those services and we're dividing those services from the tree, from the thing, and we're dividing those services from the system again. And that's the problem. So, to wrap up, two ways. One is to continue integration of issues using system theory, and the second is not to continue with the mercantilization, commodification of ecosystem services.
Thank you, Professor. I hope that answered your question. And another question?
Hello everyone, my name is Marcia from Indonesian Center for Environmental. This is actually an interesting discussion because I just want to follow up a question from the one before. As we have to integrating, and we know that we didn't have international organization on environment, and we just have UNEP, right? And we have many multilateral environmental agreements. Do you think that we need an international organization to govern the environmental law, and it has to apply the ergo omnes principle or obligation to the multilateral environmental agreements? I think it's to Professor Ezio as well.
Okay. Another hard question for you.
Okay, thank you. I would say thank you, but not thank you. Not really thank you. It is a way to do it, to have an international organization and to fight, I would say, in this arena of international organizations. So we need like a big organization to help us into the difficulties on integrate the different regimes. It is a path. However, in my experience and looking at how these regimes work, I think that it's better to go bottom up, no? And I think, for instance, the way that UIA versus RWE, which is a case in Germany about a Peruvian farmer, yes? I think that the way that that judge solved that issue, it's very useful, no? And I think that if we are able to convince more basic judges and more communities about the use of the basic tools of law to overcome the difficulty of integration, we will have a better result than if we go from up down, no?
Thank you very much. I hope that answered the question. And another question? Okay.
Hi everyone. Thank you for the very, very great panel discussion. My name is Karen from IOGI. I'm very, very intrigued with the experiences from Philippines where Nicole has shared to us. And I was wondering, how do we leverage the advisory opinion of ICJ in national courts, or even in national or regional courts where the national climate policies or development policies are actually in contrast to what the strong commitments or strong decisions that the AO has stated that the judges can leverage. So because it's an AO and one is already an existing legal policy. So how do we navigate that in courts? Maybe in Indonesia we can also reflect Balasma. So thank you.
Okay, so we have. No, that's an excellent question, and it's something that we try to address. Speaking to Judge Brandt of the ICJ, for example, it's up to civil society, because the thing with the AO that I think is a misnomer is that they say it's non-binding. That at first needs to be addressed. It's non-binding because it's not a contentious case. It's not between states, right? But then it's up to civil society to make sure that these obligations, these existing obligations, are complied with. And going back to our national setting, for example, there has been discussion, and as you mentioned this earlier, even for judges, there is a need for capacity building to understand, because again, these are unprecedented legal instruments, but even that, we've had already preliminary discussions of how to use that in courts, as the case in Germany. If there is enough, if there is knowledge and in being able to use this into domestic contents, that would be really helpful. But I really wouldn't discount, because litigation sounds, of course it's always useful, but it takes such a long time, and harms are already being done. So I'd say attack at all fronts, on advocacies, in policies. One, I think, really do not underestimate the power of reaching out, engaging with your governments. One of the strategies we employed for the UNJ resolution, for example, was we bombarded our ministries and letters to support the resolution. And that can be a strong added pressure as well, and added strategies, especially when we're drafting policies and make sure that it is compliant with the law. And I think that's one of the things perhaps we can think of, like implementation pathways and how it can be useful. But I think that's relevant because in many contexts, which norms are not as flexible, when international law are not automatically integrated into domestic law, that is challenging. And I assure you that's something that we've been trying to navigate and think through as well. And we're happy to invite everyone to join us in this process. But that is definitely a challenge. But there are ways to go around it in terms of advocacies, in terms of campaign, to make sure that civil society is empowered. We're thinking of building indicators or developing indicators for accountability to make sure that we are able to track what our governments are saying, are promising, if it matches their actions. So that can be a way as well. Thanks.
Maybe, I don't know, everyone know about it, but civil society in Indonesia use this adversary opinion. For example, when they make a lawsuit, and then the judge take it as consideration. So we try it to emphasize it by the lawsuit, by litigation or some campaign. But we know that the government, you know about the legal structure and so on. We know that it's no obligation, but we try to make this issue become bigger and known in Indonesia. I think civil society have the best, not the best, but the big part of this issue.
Thank you, Nicole and Lasma. Do we have another question? If not, I have a question for the speaker. Okay. Well, I have a question for Nicole. So we have the advisory opinion right now. Do you think that we are expecting a real case being brought to the court after this in terms around climate change issues?
Definitely, it's already happening. Even in the Court of Appeals of the Brazilian court, it's already being referenced. And I mentioned the Odette case that we're suing Shell. The AO is already being referenced by the legal counsel of the Odette, the plaintiffs, the survivors. And even though it's being heard in the UK, will also apply Philippine law. And not just that, there's also a case in South Korea, the farmers. It's the Asian context is a bit tricky because we don't have a binding human rights framework such as the Escazur, and so that's tricky. So we have to go through different strategies such as focusing on economic damage. But even that case is already referencing the AO, so we see it being used and being, again, authoritative reference already in cases, and we're and also in the European court as well. We've been tracking implementation, like how the AO is being implemented in different regions of the world. So yes, I think so.
Yeah, a follow-up question. So would you think that that advisory opinion is sort of like a driver for lawsuits at national courts only, or do you think there's going to be another case at the ICJ holding a country accountable for not doing enough?
Oh, another, you mean a contentious case, like a state versus state? Oh, you know what? We always say litigation is the last resort. If it's necessary, it is there. It is a tool, especially because the language of the ruling is very strong on justice, on climate justice, on vulnerable states, that it is an available tool, especially because it discusses transboundary harm. So it is possible. We are just careful in how we frame it, and we always say litigation as a last resort. But yes, definitely, if necessary, it can be a useful tool.
Thank you. Thank you very much. Another question from the audience? Okay, so it's time for me to ask another question then. I have a question for Lasma. So Nicole mentioned that litigation is the last resort. And also she mentioned that I guess another important thing that we can do is to influence policies. And you also mentioned that the civil society in Indonesia are also kind of doing that in terms of pushing for a better policy in Indonesia. So do you think that Indonesia will need a stronger law or policy in terms of climate change? Probably in the need of a climate change law, perhaps?
Yes. Actually, the civil society in Indonesia has consolidated maybe this year, and they want to push some new law in Indonesia. We say it's a climate change law, I think, but in still on process. They have made not litigation. They have met the government, not from the ministry, but they give some opinion about the law, but it's still on process actually. We hope maybe Indonesia make a new change by release the new law about climate change.
That is very exciting news. We are all very looking forward to how that will turn out. Another question from the audience? Not yet? Okay, so another question then to the speaker. Okay. Wow, this is going to be a hard question then.
Yes, I have question for Nicole. I'm really interested about your explanation about ICJ, a decision regarding the climate change. So, is there any country that already implemented the decision from the ICJ, yeah, to the policy in the country? I agree with you that the litigation is the last resort. So, for me as a ministry, yeah, I'm really happy if like the decision from the ICJ can, like ICEL can give to us, and then we can review together, and then perhaps you can make a suggestion to the government about this. So that's my question. Thank you.
Thank you for that wonderful question, and even more inspired and excited to hear that from the ministry, Madam Secretary Ratwani herself. There is, and in fact, but also to highlight that the ruling just came out 3 months ago in July. So there's a lot of work to do. But for example, the NDC of Vanuatu is a good starting point. In fact, there's already another UNJ resolution. It's not yet out. Another UNJ resolution by the government of Vanuatu to build political power and momentum for a resolution endorsing all the advisory opinions. Not just JICJ, but the Inter-American Court one, the ITLOS one, and I think there's even an African advisory opinion coming out. So just to emphasize that there is time to for our NDCs, for countries to for their NDCs to reflect highest possible ambition. And the NDC of Vanuatu, for example, would be a good reference point. I'm not sure perhaps the ministries would have access to that, but yes, that's already being done, especially in Vanuatu.
Thank you very much, Nicole. Any other question? No? Okay, I think we can wrap up this discussion. Thank you very much again, all the speakers. I think as a conclusion, I can say that we have a lot of international treaties. It can be overwhelming, but from this discussion, what we got so far is that these international treaties are really interconnected from one to another. So basically, we can see it as one integrated effort towards a better future for all of us. So thank you very much for sending that message to us, the speakers. And before we end the discussion, I'd like to ask Bu Vivin to also come to the stage so we can have a picture together.